Utah courts rely heavily on guardians ad litem and private guardians ad litem in custody and parent time disputes. And in many cases, their disclosures and recommendations carry more practical weight than sworn testimony from either parent or even from the child. Yet, when a parent believes a GAL or PGAL is careless, biased, or simply wrong, Utah courts are often unwilling to permit any meaningful inquiry into that concern, which raises a basic question. Why does the system presume competence of the GAL or PGAL while resisting scrutiny? And is that actually consistent with Utah law or due process? The short answer is that Utah courts presume GALs and PGAL competence because the system is built on that assumption, not because competence is established in the individual case, and that presumption is sustained by a role conflict the statutes never resolve, because GALs and PGALs are authorized both to investigate and to advocate, two functions that are conceptually distinct but procedurally merged without standards for methodology, evidentiary reliability, or testing accuracy. Utah statutes authorize GALs and PGALs to investigate, interview, and disclose information to the court, but they do not authorize them to serve as witnesses, to substitute for testimony, or to have their recommendations treated as evidence, and nothing in the statutes prohibits children from testifying voluntarily and appropriately. Yet in practice, courts often reason that once a GAL or PGAL is appointed, the child's interests are represented and the child need not be heard, a conclusion that appears nowhere in the statutory text. Once appointed, GALs and PGALs are insulated from scrutiny, not merely by judicial reluctance, but by statutory confidentiality provisions that courts frequently apply to bar access to the underlying investigative materials, creating a one-way evidentiary flow where conclusions reach the court but cannot be tested by the parties. That insulation then allows substitution, where recommendations are treated as functional evidence even though the underlying data is undisclosed, unrecorded, and immune from adversarial examination. The problem is not that GALs and PGALs exist, but that courts often rely on trust instead of proof, delegating fact-finding without retaining evidentiary discipline. Utah courts already possess the tools to manage this responsibly, including limiting discovery, distinguishing recommendations from evidence, conducting recorded in-camera interviews of willing child witnesses, and requiring reliability where factual error is alleged. Refusing scrutiny is not required by statute, it is chosen. When courts rely on insulated recommendations while excluding other admissible evidence, including a child's own testimony, they are not applying Utah law, they are deciding on faith, and faith-based adjudication is not due process.